Welcome to Legally Yours, a program designed to solve legal matters on real estate from the comforts of your home. Transactions on real estate are on the rise. At a micro level, we have our demographics, that is ruling demand and prices of real estate. For example, on one hand, we have young working adults who are investing in their first and second home properties to boost their real estate. Aging parents, on the other hand, are going in for options like reverse mortgage in order to earn additional income from their properties. Now, more transaction in real estate also mean more legal issues that need addressing. Therefore, we at Real Estate TV decided to make life a lot simpler for you. We have in our studio Vatsala Bangalore, who is a property law expert, and she will be speaking to you directly from our studio. All you have to do is pick up the phone and call up this number 096321 88388. If you would like to speak at length about your query, then you can also email us. Our email address is editorial@realestatetv.in. Both the number and the email address will continue to flash throughout the program, and you may contact us at any given time. We have one caller on the line. Vatsala, let's hear this. Hello, can you hear me?
Hello, yes.
Welcome to the show Legally Yours.
Yes, yes. Hello. இப்போ ப்ராஃபிட் இருக்கா? இப்போ லேண்ட் வாங்கினா அதை பத்தி ஒன்று கேட்கணும் உங்ககிட்ட. இப்போ இன்வெஸ்ட்மெண்ட் பண்ணா லேண்ட்ல இப்போ ப்ராஃபிட் இருக்குமா ஃபியூச்சர்ல?
டவுட்ஃபுல் கேஸ்.
Doubtful. Okay, next one. I'm only daughter.
Yeah.
அவரோட இது ப்ராப்பர்ட்டி வந்து ஆட்டோமேட்டிக்கா எனக்கு வந்துருமா இல்ல ஏதாவது ரெஜிஸ்டர் பண்ணணுமா? அது எப்படி? He is 90 years old.
Who, your father?
Yes.
And is it a self-acquired property?
Property?
Is self-acquired by your father, or did he inherit it from his father?
Madam, his property, his own property.
You will
property. Grandfather இதெல்லாம் கிடையாது. I can't hear properly.
Okay. Can you hear me now?
Yes.
Okay. You will definitely get the property after your father's time. If he leaves a will, you will get whatever is willed to you, and if he doesn't leave a will, you will
register பண்ணனுங்களா? அது
இல்ல வேண்டாம். நீங்க even without registration, will is good enough. Will is not compulsorily registrable.
அது ஏதாவது ஸ்டாம்ப் பேப்பர் ஏதாவது?
இல்ல வேண்டாங்க.
unruled சாதாரண பேப்பர்ல.
Hello
சொல்லுங்க.
You will get the property in any case without a will, or with a will which is unregistered, but the contents of the will should be known. If he leaves half to charity and half to you, that is also possible.
Okay. Thank you, madam.
Thank you.
Okay.
Next, Vatsala, we have is a question that we received over the email, and I'm going to read this out to you. This comes from Tara in Kolkata. And she writes that I'm a single parent and live with my daughter. My divorce happened on a mutual basis. I was not entitled to any kind of alimony or compensation at the time of divorce. But now I would like to know how my daughter, who is 21 years of age, can claim for a part of her grandparents, which is father's side, of property. Is there a possibility, and if so, what is the process?
See, since the divorce is already settled in court, the only recourse open to your daughter will be to claim for partition of the property if she is entitled as a co-parsoner of that property. So, you are saying it is a property of your husband's parents. So, I am presuming that there could be an element of co-parsonery in this, and since your daughter presumably is not married at the age of 21, she could be considered a co-parsoner given more facts about the case, and if it is a co-parsonary property, she can always claim partition of it. If it is on the other hand the self-acquired property of the grandparents, then co-parsonary rights will not arise, and in that case the daughter will not be really entitled to claim partition.
Could you explain me what's the difference between a self-acquired property from the grandparents' side?
Yeah, see, if the grandparents had purchased the property on their own, from their own funds, and if they are still alive, that means it is a self-acquired property of the grandparents. But on the other hand, let us say they had purchased it out of the sale of some ancestral property which they had.
I see.
Or if the grandparents had inherited it from their father, then then it becomes a co-parcenary property or a HUF property or a joint family property. In which case, the right accrues by birth. The right of every legal heir accrues by birth. That of the divorced husband and that of this daughter accrues by birth. And there is a cut-off date for the right of the daughters in various states, and it depends on whether the daughter has been married before a certain date or not to be deemed as a co-parcener, because co-parcenary rights to daughters have been recently granted.
Okay. And so if she falls under the right age, and if she is in time, she could go ahead and apply for it.
She has to be at the right age, she has to be a co-parcener, it has to be a co-parcenary property. In that case, her right accrues by birth despite the divorce, and she can apply for partition of the same.
All right. Thank you, Vatsala. And with that, we will just head for a short break, but Vatsala will keep answering questions for you right there. So keep calling us and please keep sending us emails. We will see you on the other side.